22-5165-FH. I think we have everybody here who's going to be here today. And obviously the only matter left is to instruct the jurors, and then we'll release them for the deliberations, obviously. Anything that we need to put on the record before they come into the courtroom? Mr. Wilson?
No, thank you. No, thank you.
Okay. All rise for the jury. And folks, as oddly as it may seem, you'll still sit in your same numbered seats, even if that leaves gaps in between you or in front of you. Okay, everyone can be seated. Good morning, ladies and gentlemen. Welcome back to the 12 of you. Obviously, we finished with closing arguments yesterday. The last thing that the court has to do is provide instruction to you, to give you the instructions on the law that applies to this case. After doing that, I'll go over some instructions as part of that process to just procedurally what will happen throughout the day, and then you'll be released to the jury room to complete your deliberations and begin. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about the case individually, but you should do so only after listening to and considering the opinions of other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. That is your job and nobody else's. You must think about all of the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you instructions about the law. You must take all my instructions together as the law that you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way, to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that each defendant is innocent. This presumption continues throughout the trial and entitles the defendants to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that one or more of them are guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendants are not required to prove their innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt as to one or more of the defendants, then you must find that defendant or those defendants not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. Michael Null did not testify in this case. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict as to his case in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendants are charged with a crime and are on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all of the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge that you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice that you may have and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time that you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part that you think is true and ignore the rest. The prosecution has introduced evidence of a statement or statements that it claims Eric Molitor, William Null, or Michael Null made. Before you may consider such an out-of-court statement against the defendants, you must first find that the particular defendant actually made the statement as given to you. If you find that the particular defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all of the other evidence in the case. You may consider the statement in deciding the facts of this case. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, If you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all of the evidence that you believe. You have heard evidence that before the trial, witnesses made statements that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial to help you decide how believable the witness's testimony was when testifying here in court. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you are not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The defendant's intent may be proved by what they said, what they did, how they did it, or by any other facts and circumstances in evidence. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then, you must decide whether the testimony evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard that a lawyer talked to one of the witnesses. There is nothing wrong with this. A lawyer may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You have heard evidence about defendant Eric Molitor's character for peacefulness and citizenship. You may consider this evidence together with all of the other evidence in the case in deciding whether Eric Molitor committed the crimes with which he is charged. Evidence of good character alone may sometimes create a reasonable doubt in your minds and lead you to find the defendant not guilty. The prosecutor has cross-examined Eric Molitor's character witness as to whether they heard anything bad about the defendant. You should consider such cross-examination only in deciding whether you believe the character witness and whether they described the defendant Eric Molitor fairly. You have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. Even if the defendant knew the alleged crime was planned or was being committed, the mere fact that he was present when it was committed is not enough to prove that he assisted in committing it. Eric Molitor is charged with the crime of providing material support for an act of terrorism. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that Eric Molitor provided material support in the form of personnel, surveillance, any related physical assets or intangible property, and or expert services or expert assistance to Adam Fox and or Barry Croft. Second, that when Eric Molitor provided material support to Adam Fox and or Barry Croft, he knew that Adam Fox and or Barry Croft would use that support or those resources, at least in part, to plan, prepare, carry out, facilitate, or avoid apprehension for committing an act of terrorism against the United States or its citizens, Michigan or its citizens, a political subdivision or agency of Michigan, or a local unit of government. An act of terrorism is committing or attempting to commit the violent felony of murder, assault with intent to commit murder, assault with intent to commit great bodily harm, arson, or kidnapping that was or would be dangerous to human life and was intended to intimidate or coerce a civilian population or influence or affect the conduct of government or a unit of government through intimidation or coercion. Murder, assault with intent to commit murder, assault with intent to commit great bodily harm, arson, or kidnapping are violent felonies. You must decide whether the crime was or would have been dangerous to human life, and whether the defendant intended to intimidate or coerce a civilian population, or intended to influence or affect the conduct of government or a unit of government through intimidation or coercion by committing one of those felonies. Eric Molitor is also charged with the separate crime of possessing a firearm at the time he committed the crime of providing material support for an act of terrorism. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that Eric Molitor committed the crime of providing material support for an act of terrorism, which has been defined for you. It is not necessary, however, that Eric Molitor be convicted of that crime. Second, that at the time Eric Molitor committed that crime, he knowingly carried or possessed a firearm. It does not matter whether or not the firearm was capable of firing a projectile or whether it was loaded. A firearm includes any weapon which will or is designed to or may readily be converted to expel a projectile by action of an explosive. A pistol is a firearm. William Null is charged with the crime of providing material support for an act of terrorism. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that William Null provided material support in the form of personnel and/or surveillance to Adam Fox and/or Barry Croft. Second, that when William Null provided material support to Adam Fox and/or Barry Croft, he knew that Adam Fox and/or Barry Croft would use that support or those resources, at least in part, to plan, prepare, carry out, facilitate, or avoid apprehension for committing an act of terrorism against the United States or its citizens, Michigan or its citizens, a political subdivision or agency of Michigan, or a local unit of government. An act of terrorism is committing or attempting to commit the violent felony of murder, assault with intent to commit murder, assault with intent to commit great bodily harm, arson, or kidnapping that was or would be dangerous to human life and was intended to intimidate or coerce a civilian population or influence or affect the conduct of government or a unit of government through intimidation or coercion. Murder, assault with intent to commit murder, assault with intent to commit great bodily harm, arson, or kidnapping are violent felonies. You must decide whether the crime was or would have been dangerous to human life and whether the defendant intended to intimidate or coerce a civilian population or intended to influence or affect the conduct of government or a unit of government through intimidation or coercion by committing one of those felonies. William Null is also charged with a separate crime of possessing a firearm at the time he committed the crime of providing material support for an act of terrorism. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that William Null committed the crime of providing material support for an act of terrorism, which has been defined for you. It is not necessary, however, that William Null be convicted of that crime. Second, that at the time that William Null committed that crime, he knowingly carried or possessed a firearm. It does not matter whether or not the firearm was capable of firing a projectile or whether it was loaded. A firearm includes any weapon which will or is designed to or may readily be converted to expel a projectile by action of an explosive. A pistol is a firearm. Michael Null is charged with the crime of providing material support for an act of terrorism. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that Michael Null provided material support in the form of personnel and/or surveillance to Adam Fox and/or Barry Croft. Second, that when Michael Null provided material support to Adam Fox and/or Barry Croft, he knew that Adam Fox and/or Barry Croft would use that support or those resources, at least in part, to plan, prepare, carry out, facilitate, or avoid apprehension for committing an act of terrorism against the United States or its citizens, Michigan or its citizens, a political subdivision or agency of Michigan, or a local unit of government. An act of terrorism is committing or attempting to commit the violent felony of murder, assault with intent to commit murder, assault with intent to commit great bodily harm, arson, or kidnapping that was or would be dangerous to human life and was intended to intimidate or coerce a civilian population or influence or affect the conduct of government or of a unit of government through intimidation or coercion. Murder, assault with intent to commit murder, assault with intent to commit great bodily harm, arson, or kidnapping are violent felonies. You must decide whether the crime was or would have been dangerous to human life and whether the defendant intended to intimidate or coerce a civilian population or intended to influence or affect the conduct of government or a unit of government through intimidation or coercion by committing one of those felonies. Michael Null is also charged with the separate crime of possessing a firearm at the time he committed the crime of providing material support for an act of terrorism. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that Michael Null committed the crime of providing material support for an act of terrorism, which has been defined for you. It is not necessary, however, that Michael Null be convicted of that crime. Second, that at the time Michael Null committed that crime, he knowingly carried or possessed a firearm. It does not matter whether or not the firearm was capable of firing a projectile or whether it was loaded. A firearm includes any weapon which will, or is designed to, or may readily be converted to expel a projectile by action of an explosive. A pistol is a firearm. The definition of the word personnel, as found in the jury instruction for providing material support for an act of terrorism, can include providing oneself. At various times during this trial, one or more of the defense attorneys has advanced a theory of entrapment by the government and its agents. Put another way, the defense has attempted to elicit evidence that the government and its agents engaged in activities that impermissibly manufactured or instigated crimes in this case. However, entrapment is a legal theory that is a matter of law for the court to decide. In other words, it is for a judge, not a jury, to decide whether entrapment is present in this case. As such, whether a defendant was entrapped by the government and its agents is not a question for you to decide. In so instructing you, the court is not trying to keep anything relevant from you. This is done only because entrapment is not an issue relevant to your determination of whether the defendants are guilty of the charged crimes. That is a determination that you as the jury and you alone must make. In so instructing you, the court is not commenting on the truthfulness or veracity of a given witness, the quantity or quality of evidence against any defendant, or whether any of the defendants are guilty of the charged crimes beyond a reasonable doubt. Again, those determinations are for you and you alone to make. The prosecutor must also prove beyond a reasonable doubt that the crimes occurred on or about November 1st, 2019 through October 7th, 2020 within Antrim County. The alleged crimes in this case are made up of several acts. The prosecutor only has to prove that one of these acts took place in Antrim County. He does not have to prove that all of them took place there. When you go to the jury room, you will be provided with a written copy of the final jury instructions, actually 3 copies. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business-like way and that everyone has a fair chance to be heard. During your deliberation, your cellular phones and other electronic devices will be collected. This would include smartwatches, for example. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual, considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations, or questions about the instructions, or if questions arise about the instructions during deliberations, you may submit them in writing in a sealed envelope to the bailiff. So ladies and gentlemen, what will happen, there are no sealed envelopes, for example. What will happen is the foreperson will simply send out a note, much like you have with the questions that have been submitted already, and then we'll talk about it. And if whatever answer we come up with, we would then bring the jury as a whole back into the courtroom, provide you the answer, and then excuse you to continue with your deliberations. Possible penalty should not influence your decision. If you find any of the defendants guilty, it is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the bailiff. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in this case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. And we'll go over the verdict forms in just a few moments, ladies and gentlemen, but as I told you, you've heard us say verdict or verdicts. It's actually 6 verdicts or 6 decisions that you'll make. Each one of those has to be unanimous, so a unanimous decision as to each charge for each defendant. When you go to the jury room to deliberate, you may take your notes and the full instructions. If you want to look at any or all of the reference documents or exhibits that have been admitted, just ask for them. Again, one slight variation from the standard instruction, the exhibits will be provided for you. They've electronically, or at least most of them electronically, will be on what we call a clean computer. We refer to it in that way only because it can't connect to the internet, for example, so you wouldn't be able to do any outside research, which is prohibited. Also, right, one side or the other doesn't get to name anything or put any notes on there or anything like that. It's just a computer for you to view the exhibits. The other thing that we'll send back with you is the big exhibit book that you've seen things referred to, right? The big stack some of the witnesses have gone through. So you'll have both of those to use. The one thing I would ask for, especially the big evidence book, you have been given, for example, copies of some of the exhibits that have stickers on them. Just make sure that whichever what I'll call the official exhibit that's in the book, if that gets taken out, that's the one that would need to go back in because it's simply maintained by the clerk as part of the court record after the trial. Okay. And again, as I said, you'll also get 3 copies of the instructions to be able to go through. As I said, when you go to the jury room, you will be given 3 written copies of the instructions that you just heard. As you discuss the case, you should think about all of my instructions together as the law that you are to follow. The defendants are each charged with 2 counts, that is, with the crimes of providing material support for an act of terrorism and possession of a firearm at the time of commission or attempted commission of a felony, also referred to as felony firearm. These are separate crimes, and the prosecutor is charging that each defendant committed both of them. You must consider each crime separately in light of all of the evidence. You must return a separate verdict for each defendant. For each defendant, you may return a verdict of guilty of one or more of the alleged crimes or not guilty. Remember that you must consider each defendant separately. So, ladies and gentlemen, as I said, you'll be given 3 copies of the instructions. You'll also be given 3 verdict forms. There's 1 verdict form for each defendant, and they list count 1, and then it's 2 options for each count. So, for example, not guilty of providing material support for an act of terrorism or guilty of providing material support for an act of terrorism. Once the jury has reached a unanimous verdict as to, I'll just use one of the first defendant as to that charge, the foreperson would mark the appropriate verdict. Similarly for count 2. The foreperson would then date and sign the verdict form. That would be done for each of the defendants. Once you all have reached a unanimous verdict on each count for each defendant, so 6 total decisions have been made and all 3 verdict forms have been filled out, you would simply knock at the door and then provide a note that just says the word verdict. Don't tell anybody what the verdict is, okay? We will then bring the entire jury back into the courtroom. The foreperson, whoever that is, would bring the 3 verdict forms. That person will actually stand, and then the clerk will, what we call, receive the verdict, meaning basically ask what the verdict is as to each count for each defendant and go through in that fashion. Okay, so that's the procedural that will be used. So what we'll do is excuse you from the courtroom to go into the jury room for deliberations. Much like I told you yesterday, I think at the beginning I joked with you that you could go for walks because we're not trying to lock you in the room. Now we're trying to lock you in the room, okay? So you are limited to the jury room. You're not allowed to leave it. If it gets to around lunchtime, for example, we'll provide you with a menu and bring food in for you. Just an example procedurally with time, and again, I'm going to give you the caveat that I've given you at every point. If I give you sort of a procedural or example of what we may do at about lunch, for example, or at the end of the day, that is not to presume that deliberations will still be going on at that time. The length of deliberations is entirely up to the jury. I just simply want to let you know kind of going forward how we can proceed. So at lunch, we'll provide a menu to you. You'll make those selections and the food will be brought in. If your deliberations are still ongoing towards the end of the day, when it gets to about 4:30, what I generally do with all juries is I'll bring everybody back in and then sort of leave it up to you in a sense and have you go back in the jury room for a few minutes and talk about what you want to do. Would you like to stop at 5 as we traditionally have and then come back the next morning? Would you like to keep going into the evening? those types of things will be left up to you. And then what would happen is your foreperson would simply write the answer down on a note, pass that back to us so that we know how we're going to proceed. Okay, that's not to, I'm not trying to tell you that you should keep going or stop or whatever it is. Those decisions are entirely left to you. Okay, what we'll do is we'll send you back to the jury room. I'm going to talk to the attorneys just to make sure, and I know that I made them stay late the other day to compile all the exhibits, so I know they're all there, but I just want to confirm that. Then we'll provide those to you along with the 3 sets of instructions and the verdict form. So again, the first thing that you'll need to do is select who the foreperson is going to be. While we're out here doing those administrative tasks, I'll say that would be a good time if anybody does have a question procedurally about the instructions or anything. It would be a good time to write that down so that you can send those back out while we're all here and can potentially answer them for you. If we don't receive any, we'll simply send the exhibits back along with the other information, and then you'll deliberate until you let us know that you have a question or have reached a determination. Okay? All rise for the jury. Okay, the door is closed. The record can reflect the jury is outside the courtroom. Everyone can be seated. First, let me go around the room and with this question, no one is waiving any objections that they have already made. I'm simply asking, based on the determinations the court has already made, do the parties agree that I have read the instructions that I determined the other day to be correct? Mr. Ralston?
Yes.
Mr. Nunzio?
Yes.
Mr. Seibert?
Yes, Your Honor.
And Mr. Barnett?
Yes, Your Honor.
Okay. I would note too for the record, I don't normally do this, but given the case, I did provide the copy that I read to the clerk's office, and they will be filed online so that they are part of the record, just so that it's clear. Exhibits are all set, I presume, and ready to go.
They've been justified. We've gone over this individually and as a group. We're satisfied that we have all the exhibits. I do have footnotes for the court.
Okay.
Okay, the computer that we're using has the Wi-Fi turned off. It is impossible to go in and remove the Wi-Fi function. In other words, a clever individual could probably go into this computer and activate the Wi-Fi. I've discussed this with our other counsel. It doesn't seem to be a deep concern. If the court, harbors a deeper concern, then it's my recommendation that we turn the Wi-Fi off in the building.
They've been instructed several times not to do any outside research. And quite frankly, as with all technology, if somebody wants to find a way, they're going to find a way. I mean, if somebody's that adept at it, they're going to get around it. So I don't have any concern given the number of times I've instructed them not to do any outside research. So, but in terms of the exhibits being all set, Mr. Ralston, you agree that they are?
Yes.
Mr. Nunzio?
Yes.
Mr. Seibert?
Yes.
And Mr. Barnett?
Yes.
Okay. So Ms. Bruno, we need to swear in the bailiffs. As I let the parties know, both Sergeant Knight and Ms. Bruno will both be sworn in, just given where they might be in the courtroom. They may both be in a position to receive notes from the jury. So I want to have them both sworn in. So Madam Clerk, if you would swear in the bailiffs, please.
Do you solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them, and that you will not communicate with them except upon order of this court, or to ask them if they have agreed upon their verdict until they shall be discharged, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon? And do.
Okay. So what we'll do, these are the 3 sets of instructions and the verdict form that have been agreed to. Verdict forms, excuse me. Give you those. And Sergeant Knight, if you want to help carry those back, and then we'll be seeing to make sure that we can collect all of the electronics.
Yep.
And then we're good to go. Okay. Ladies and gentlemen, a couple of things that I want to go over with everybody, but first, just a reminder, I don't remember if I said it on the record or not, but I did let the parties know that the court has a 5-minute rule, so to speak. I realize that other things are happening in the world. The attorneys may have hearings and different things like that. What I've simply asked the parties is that basically everybody be able within 5 minutes or so to get back to the courthouse if there's a question or a verdict, whatever it may be. That is not to say that if somebody is eating lunch, they need to dine and dash to get back. Okay, I'm not encouraging that. If it takes 10 minutes or whatever, that's fine. Much like I say, our breaks are going to be 5 to 10 minutes and they end up being 15. I understand there's some wiggle room. Thank you, Mr. Vanderson. The other thing I want to tell everybody, I guess I don't normally say this part on the record, but as much as I've said it's a normal case up until now, it's actually not. But I want to thank all of the parties for the demeanor and behavior in court. I want to thank all of the people who have been here for the same thing. I'm not going to tell you that I know what it's like to sit there, and I'm not going to BS you and tell you that, and I'm not going to tell the family members and friends that I know what it's like to sit there. I appreciate everybody maintaining decorum throughout this entire process, no matter what was said. And along with that, though, I will ask that it continue through the verdict. There can be no outward expression of any kind, no outbursts, no matter what the verdict is, as to each defendant. Again, I'm not going to tell you I know what it's like to sit there and have to listen to that. And I know it's been a long road, so to speak, for everybody in this room, much longer than it has been for me. But the decision by the jury is final. I'm just going to pause for a moment while they're coming out of there. And whatever decision it is will be respected by everybody. There will be plenty of time to process it after that. But while they are in the room, certainly, no outbursts of any kind. The other thing I want to take some time to do that I don't normally do on the record, but again, it's not a normal case, is I want to thank everybody involved, and that goes beyond the people who are sitting in this room. This was a large footprint, so to speak, to bring to Antrim County in terms of the number of potential jurors, let alone the number of jurors that sat through the entire trial, the number of departments that we had to coordinate with ahead of time, both employees of Antrim County, and I'm going to forget certain departments, to be sure, but you know, whether it was facilities, whether it was IT, whether it was the clerk's office who had to provide folks, that certainly greatly appreciated by the court. I know that this is not normal, so to speak, for us to have something of this scope, and it was a lot for everyone to work through. I appreciate everybody in this room, whether it was the media, the parties, everybody working together to work through where is a camera going to be, how can we position something so that we make sure a witness can be shown so that the jurors are not. You know, those are all things that it was a lot of balls to juggle, so to speak, and everybody's cooperation made it a much smoother process, and I don't know, easy is the right word, but simpler, to be sure. And that was greatly appreciated by me throughout the duration of this process. And last but not least, certainly the Sheriff's Department, I know in terms of personnel, both uniformed and not, I appreciate all of the extra efforts for them and local law enforcement to ensure that we didn't have any issues arise during this process. That was greatly appreciated as well. So I'm sure there's plenty of people I'm leaving out, such as the staff of the court, and I do appreciate their extra effort as well. But I do thank everybody. It was as smooth as it could be, I think. It's the way that I'll describe it for the scope of what it is. So with that, we will be in recess until we hear from the jury either way. So again, I just ask the parties to remain in contact. If each of the attorneys could make sure that our staff has your cell phones, just so that we can at least text you or get a hold of you that way, we'll ensure that we get everybody back timely if necessary. Okay, thank you all. We'll be in recess.